I'm not your bro, I'm not your man, and I'm not to be interrupted when I'm speaking. Just because you're unsatisfied with the way that I rule, then that's not my problem.
Hey everyone, welcome back to the channel. Today, we're heading into Judge Perkins' courtroom for another tense encounter with a sovereign citizen who appears convinced that his interpretation of the law is superior to that of practicing attorneys and the judge sitting right in front of him. Things are about to get interesting. So let's jump straight into the courtroom and see how this one unfolds.
City of Detroit versus Christopher Perry Lewis, case number SP 151-06611. Appearance for the record, please.
Sherika Harris on behalf of Mr. Lewis. Please state your name for the record.
I don't have an attorney. I'm representing myself. I articulated that at the last hearing.
Today is the date and time set for a ring on the bench warrant. I'm going to enter not guilty plea on his behalf. I'm going to give him a $0 bond. Mr. Lewis, you said you were here last time. Why did you miss your date?
I actually didn't miss the date. I actually sent you a motion today to show you proof that I was actually in the hearing, and I was locked out of the hearing after an hour of waiting. As well as I sent you a motion for dismissal as well. I sent it last week. Yes, I sent it last week, but I resent it today, and I sent it in a Zoom chat as well to the prosecutor, the clerk, reporter, as well as the clerk.
I didn't get that motion, either of those motions.
Is there any way you have availability to look at the Zoom message, right? I sent it to not only your email, but the Zoom chat as well.
I need it in my email. I
sent it twice. I can tell you my email if you want to search it, but you should have it twice in your email. I resent it.
What's your email?
Chris, CHRISLEWIE, Midtown, that's MIDTOWN @gmail.
Chris CHRISL, right?
Yes, EWIE.
I don't have it.
So the self-proclaimed legal expert can't even manage to send a basic email correctly. That's pretty ironic for someone who's so confident that he understands the law better than everyone else. But apparently, even the simplest task is proving to be a challenge.
Okay, I'm resending at the moment.
I'm gonna put my email address in the chat. And I'll put my email so you'll have it, and send that to me, and I'll have an opportunity to read that. I'll confirm that I'll wait to confirm that you send it to me, and I'll give you a date. The next court date is going to be a pretrial date on May the 28th, 2024 at 8:30. You need to get a copy of that to the city attorney as well.
I'm actually just sending it to the prosecutor as well. Dia Mason, is that her?
Yes.
Prosecutor? Yes, I did just send her attachment. If she could send me a confirmation that she received it.
Get it to her email address. So Mrs. Mason, you put your email address in the chat as well, so Mr. Lewis can get you a copy of that.
I really appreciate that.
File of that motion. Both motions that it has. All right. I'm going to wait on that. Once I confirm that you gave me that, I will recall the case.
So after countless attempts, and apparently enough glue to keep a craft store in business, he finally managed to get his email through to Judge Perkins. But the victory didn't last long. Judge Perkins only needed to read a few lines before dismissing the entire thing, and that clearly didn't sit well with our self-proclaimed legal expert. The quick rejection seemed to send him straight into another meltdown.
Let's go back on the record with Mr. Christopher Lewis. I have received this motion, and I read the first couple of lines of it, and that I'm not concerned necessarily about the March 18th incident. I don't know what happened on that day, but you are here now, so we'll move forward.
Excuse me, sir. I heard you say that you only read the first couple lines. Is there any way we could possibly take another case until you get the chance to read the entire thing? It's only 2 pages.
I'm not going to read this entire thing today.
It's only like 3 paragraphs, the entire thing. The rest are just case sightings.
All right, I'm gonna deny the motion. I will set the matter for
Is there
a
any way I
trial.
can get a written? Can I get a written articulation as to why you're denying the motion?
I'm denying the motion,
I would just
because
appreciate a written excuse. Can I get a written articulation?
I might give it to you in writing.
Are we on record? Are we on record?
We're on record.
Okay. Is this court bound by the U.S. Constitution and Supreme Court rulings?
Yes.
Okay, you were denying my motion when I said that I had Fourth Amendment violations, and you're saying that you're denying my motion without looking into it or granting me a hearing to go over my motion, or give me an articulation as to why, a written excuse as to why. I want to make sure that that's what you're saying to me.
You're asking for a change of venue. I'm denying.
I'm saying that no, there's a motion for dismissal, and I'm saying that you, as an Article 1 judge under the Commerce Clause, if you're not going to uphold my due process and my Fourth Amendment, I'm saying that maybe we could change venues where I could get a real judge.
At least you're dealing with an actual judge, not some imaginary article judge, like you claimed earlier.
I insist that
but
the
we'll
court
come back
give me
to that in a moment.
a written
What you still don't seem
excuse
to
as to why you're
understand
denying
is
my
that a
motion,
change
so
of
I can
venue
take that to the
isn't some
Senate.
free pass
Okay?
that lets you move
Well,
your
you can
case
insist
from
all
one
you want
courtroom
to.
to another
Okay,
whenever you don't like the
I
outcome.
appreciate that.
You don't get
I'm
to switch
telling
courts
me
simply
today
because
why
the
you're not gonna
judge
look into
isn't
it
giving
or
you the
give me
answer
a
you
hearing.
wanted.
Okay, I'm denying the motion to dismiss. Okay, I'll set a trial date for you so you can be heard on that type of form.
I insist that the court give me a written excuse as to why you're denying my motion, so I can take that to the tenor. Okay.
Well, you can insist all you want to.
Okay.
You get a
I appreciate that, but I'm telling you, you're telling me today why you're not going to look into it or give me a hearing. That's so I can go over the evidence that I have to present to go with my motion. You don't want to do any of that. So I'm just asking that you can give me a written excuse that I could go take and complain against you on, because that's violating my due process. You didn't even give me the chance to say we're going to schedule a evidentiary hearing or something like that. You're going to sit up here and disregard that when I made genuine claims and put genuine evidence in there. Overwhelming.
If your argument were actually as overwhelming as you claim,
no victim, no loss.
the motion wouldn't have been denied.
And in a minute, it's going
The
to
fact
be
that
malicious
Judge Perkins
prosecution.
rejected
So
it tells
I'm
you
asking you
exactly
to
where
dismiss
the
this charge
problem
or
was.
change the venue.
The same
If you
recycled
refuse to do
sovereign
that,
citizen
I'm asking you
arguments
for a
were
written
brought
excuse
before
so
the
I can
court
take it to the
again.
tenor, sir.
And it
That's what I'm
apparently
telling
didn't
you.
take Judge Perkins
Because
long
if
to
not, I'm
recognize
gonna go to the
that
tenor
they
without
weren't
it,
supported
let them know
by
that
a
you
legitimate
refuse
legal
to
basis.
give me a written
Sometimes a
excuse.
judge
and
doesn't
you
need pages
refuse
of
to
explanation
give me an
to see
evidentiary
that an
hearing,
argument
but you just
simply
straight
doesn't
denied
hold
it.
up
When
under
you
the
just
law.
5 minutes. So at the end of the day, like I said, there's no crime. This is a fraudulent charge. Y'all don't have. There's no suspect. Y'all suspect me for no crime. There's no victim, no losses. Okay. And in a minute, it's going to be malicious prosecution. So I'm asking you to dismiss this charge or change the venue. And if you refuse to do that, I'm asking you for a written excuse so I can take it to the tenor, sir. That's what I'm telling you. Because if not, I'm going to go to the tenor without it and let them know that you refuse to give me a written excuse and you refuse to give me an evidentiary hearing, but you just straight denied it. When you just 5 minutes ago, you said you didn't even read it. Now you just denied it. That's conflict of interest. That's bias. That's all that. So let's put it all on record. If you feel just as strongly as you feel, give me a written excuse. If not, let's change venue. Because you're an Article 1 judge under the Commerce Clause. This conflict of interest, you only here to make money, man. You know what I'm saying? It ain't no crime.
Wait a minute.
Ain't no victim or no
man.
loss, bro.
I'm not your, listen, I'm not your man.
Look, sir. Hey, sir, respectfully, you're an Article 1 judge under the Commerce Clause. You've been on the bench since what, 21? Couple years? You need to talk to somebody.
Oh, he's dealt with plenty of people making these same arguments before. But so far, none of them have managed to present anything that actually holds up as a legally persuasive argument. So unless you've somehow uncovered some secret sovereign citizen loophole or hidden court information that nobody else has ever found, you're probably not bringing anything new to the table. And if the arguments are just the same recycled claims we've heard countless times before, then this isn't going to turn into some groundbreaking legal victory. Instead, it's likely to become another courtroom moment where the defendant unintentionally provides everyone watching with plenty to laugh about.
I'm asking you to give me an evidentiary hearing to go over my motion for dismissal with the overwhelming evidence or change venue. Because if not, I'm going straight to the tenor right after this. And that's on you, sir. You had this. You did this.
Oh, all right. Now I'll let you speak.
Straight like that.
No, That's all we need. I don't want to hear any
All
more
right,
from
cool.
you.
It's cool.
You made
I'm
your,
not.
you made
I
your, you
appreciate
made
it.
your record.
You.
No,
This
don't
due
interrupt
process.
me.
This
I
a
didn't
due
interrupt
process
you.
violation. This is a due process violation right now. And the way y'all tried to railroad me when I was ready to argue my trial. I told you I was here to argue my trial. Y'all locked me out. Now you're trying to start the process over. They not prepared to present a case. I'm telling you. They're not prepared to present an injured party. So what we doing?
Listen. Please do not say any more. You've already made your record. I've given you that opportunity. If you continue on, especially interrupting me while I'm talking, because I didn't interrupt you while you were talking. I'm not your bro, I'm not your man, and I'm not to be interrupted when I'm speaking. I gave you the respect and the right to speak. Just because you're unsatisfied with the way that I ruled, then that's not my problem. You take whatever, wait a minute, let me say it. You take whatever recourse that you feel that is necessary. Now, what I can do, Mr. Lewis, is I can set you a jury trial date. And at that jury trial date, you will have an opportunity to represent yourself or do whatever you want to do and put all your proofs on the record by a jury of your peers, and you can argue it that way, okay?
A jury of his peers? You mean a group of third graders? If that's the level of confidence he has in his own legal argument, he's certainly going to need some luck.
I appreciate that, but I was still like a written.
You order the transcript. You order the transcript. It's in the transcript. You asked me to read the couple of paragraphs that you made. Most of the paragraphs was referencing the incident on March 18th, as you and I'm not even debating or disputing it. I said I'm not concerned about March 18th or any missed date. I said that the most of what you're saying is in the it's not I'm not even going to hold you to that, but in paragraph 2. Moreover, I want to emphasize that the initial charge against me in this court is fraudulent. I don't know that to be the case. That's why I'm giving you an opportunity to have a jury trial, and they can make a determination. Neither the complaining witness or the prosecution is prepared at any point of this case to present an injured party or any reported damages / losses. So it becomes abundantly clear that every proceeding taking place is strictly an attempt to seek funds where there is no crime and not seek real justice. So we are giving you real justice, because if you say that there's been no crime, then you have a right to a trial. And that's what I'm giving you. So I was assaulted, detained, and my property illegally searched and seized with no suspicion of crime at the hands of the complaining witness, Joshua Martin, and assisting officers. I do not consent to these fraudulent proceedings and demand that the court dismiss the charge immediately with the appropriate remedies. And I'm dismissing the motion based on that, because I am giving you a proper forum to argue your case, or allow me the right to change the proper venue of federal court where my U.S. constitutional rights will be upheld and not disregarded by Article 1 judge under the Commerce Clause. I don't understand that.
That's quite an explanation, but the distinction he's trying to make is pretty straightforward. Article 1 judges are generally federal judges whose authority comes from Article 1 of the U.S. Constitution. Judge Perkins, however, is a state judge. So his judicial authority comes from Michigan state constitutional and statutory framework, not from the same federal provisions that govern Article 1 courts. But simply making that distinction doesn't automatically invalidate the authority of a state judge or give a defendant the right to disregard the court. The real question is whether the judge has lawful jurisdiction over the specific case.
Indicating a clear conflict of interest, I do not wish to proceed with this matter. You don't have to proceed any further because I'm dismissing the case. He did cite some case law. It was at Sherrar v. Cullen, 481 Federal 2nd, 945. For a crime to exist, there must be an injured party, corpus delicti. There can be no sanction or penalty imposed on one because of the U.S. constitutional right. Louisville versus Motley, 211 U.S. 149, South 29 S period court CT 42. Any tribunal court finds absence of proof of jurisdiction over a person or subject matter, the case must be dismissed. The accuser bears the burden of proof beyond a reasonable doubt. All right, so I'm dismissing the motion. All right, and you can get a copy of that record on of what we just made by going through the proper channels of the court to get the court reporter to produce that record.
I can't even get the court reporter to respond to my voice messages or you to respond to my emails, sir.
The court reporter is not going to respond to your voice message. The court reporter is going to respond to you
The
coming down.
36th district told me to call her the day that I was locked out of my trial date. I had a scheduled trial. The court told me to call her that day, and I called her that day, and she still hasn't responded. So I'm trying to see if the court that you work for is trying to tell me how the appropriate channels, and then y'all doing it different in y'all court. What am I to do?
I think you're talking about the court clerk and not the court reporter. There's a distinct.
Yeah, I was told to call the clerk the day that I was locked out. The moment I was locked out.
We've moved past that getting locked out.
But that was my trial date.
Yeah, so I'm giving you another.
How soon can I get another trial date, sir? How soon can I get another trial date? That's what I'm asking.
That's what we're trying to do now.
A jury trial.
A jury trial. I'm gonna let the jury of his peers hear what he has to say.
I love how he's basically saying, I'm not dealing with this. Maybe he's hoping that if enough people from Michigan tell him he's completely misunderstanding the situation, he'll finally realize that his argument isn't going anywhere.
July 23rd, 2024 at 9 a.m.
July 23rd?
Yeah, 2024 at 9 a.m. We'll have a final pretrial the day before.
Why would we need a final pretrial? Why would we need a final pretrial?
Because I said I wanted one.
But that's how you protecting your interest. You protecting your interest, and you're gonna dismiss it on that date. So you trying to play with me? You could dismiss it today, bro. You literally, but
a final pretrial 8:30.
You are literally violating my due process. You can't even give me a written excuse, but you want all this whole.
Mr. Lewis, I know you don't want counsel, but is it possible we could talk in a breakout?
Excuse me, ma'am. Excuse me, ma'am. I am in pro se. I'm in pro se.
Go wherever you want to. Final pretrial of July 22nd. I am. Date is going to be July 23rd. All the parties must appear on the final pretrial date, and the jury, and that can be on Zoom. And the next day, the jury trial date is in person. Have a very good day, Mr. Green. Best of luck to you.
That's not my name.
Yeah, Judge, get it right. His name is Dumbfuck McDickflute L. Bay. And you know Judge Perkins had to throw one more jab in there before he left.
Put him out the room, please.
Yeah, Judge Perkins definitely got the name right, and he couldn't resist getting in one final jab before sending him out of the courtroom. And that's going to wrap up today's video. I'm finally back from my trip and ready to get back to work. I also want to give a huge thank you to everyone who continued watching while I was away. Reading your comments throughout the trip genuinely kept me entertained, and I really appreciate everyone who takes the time to leave one. If you enjoyed the video, hit the like button and let me know what you thought in the comments. If you didn't enjoy it, that's okay too. Tell me why. And don't forget to subscribe and turn on notifications so you don't miss the next courtroom breakdown. Thanks for watching, everyone. I'll see you in the next one.